right, I'm taking Sadie with me.
Okay.
Did you do it live?
It's fine.
All the other ones were live.
Well, I'd like to welcome everybody to the fourth in our series on the Parole Spotlight series we've been hosting this week. We've had a great lineup, and if you have missed any of the first three segments of this series, I would suggest that you take a look on Facebook. Yesterday, we had former Governor George Allen talking about the Truth in Sentencing initiative that was a bipartisan initiative during his gubernatorial term. It actually was the first initiative that was addressed in a special session of the General Assembly. The day before that, we had Phil Ferguson, the 40-plus year Commonwealth's attorney of the city of Suffolk, talking about really shocking couple of cases that he prosecuted. Patrick Schooley, who was convicted of the rape, robbery, abduction, and murder of a 78-year-old Suffolk woman, and Patrick Schooley was just released back to the community by the parole board without Phil Ferguson or the victim's family ever receiving any notice, notwithstanding the fact that it is statutorily required. And on Monday, we had Stacy Martin, who is the Commonwealth's attorney in Halifax County, talking about Deborah Scrivener, who was just convicted 8 years ago in connection with talking her 15-year-old grandson into murdering his father and her son-in-law. It was just 8 years ago that she was convicted. Notwithstanding the fact that she had a long sentence, this parole board released her without giving notice to the Commonwealth's Attorney's Office or to the family of the victim. Today, we have the last in this series, and quite frankly, this is, I think, one of the most troublesome acts of the parole board during the course, well, really, so far as I'm concerned, ever.
Give us a minute, folks. I think we got a
Richmond City Police Officer Michael.
Hey, Mark, you just froze for about 20 seconds. If you want to recap the last 20 seconds of what you were talking about.
Yeah. All right. Well, thank you. Today, we're going to talk about the case that really has been highlighted in the press all over Virginia and frankly across the country. It involves the parole, the decision by this parole board, the Northam administration appointed parole board, their decision to release Vincent Martin, who was convicted of the capital murder of Richmond City Police Officer Michael Connors. And today, we've got a Richmond lawyer, happens to be the lawyer who was a prosecutor in the Richmond City Commonwealth's Attorney's Office who prosecuted Vincent Martin. I want to welcome Stacy Garrett. Stacy, welcome. Nice having you.
Welcome, Senator Obenshain. Nice to be with you. Thanks for the invitation.
So tell us, you were a frontline prosecutor back in the 70s and 80s, is that right?
Yes, I was in the Commonwealth Attorney's Office from 1975 through 1994. And at the time this happened, I was Deputy Commonwealth Attorney.
And why don't you start out, and you prosecuted Vincent Martin. You
Yes.
led the prosecution team.
Jerry Davis, the Commonwealth Attorney, and I both prosecuted Mr. Martin.
and during the, and he had 2 trials, is that right?
Yes, he did.
So why don't you start by telling us about the crime itself, the murder of Officer Michael Connors?
Let me start by saying about 3 o'clock in the morning on November 13th, 1979, I received a telephone call from Aubrey Davis, Jerry Davis, my boss, saying, "Garrett, get up, get dressed, get down here. A police officer's just been shot and killed." I got up, got dressed, kissed my wife goodbye, and said, "I don't know when I'll see you, next see you," but I knew I had a long road ahead of me. I got down to the police station, and we found that about 10 minutes, or roughly 5 to 10 minutes before Officer Connors was killed, 4 individuals went to a 7-Eleven. One person, Jeffrey Short, stayed in the car. The other 3 went inside, robbed the 7-Eleven, and incidentally received for their efforts $21 bills. That's important later on in the story. They got in the car and were driving west on Main Street, past Belvedere, and going into the next police precinct, got past the mosque, and Officer Connors pulled up behind him, having radioed that he was making a traffic stop. We don't know why.
Traffic stop even connected with robbery?
We don't know. We don't know because we don't know why. He never communicated why he was stopping all this, just making a traffic stop. We know from the testimony of the individuals that when the red lights went on, one of the individuals told the driver, "Hey, just pull over, give the police officer your driver's license, he'll give you a ticket or whatever, and we'll go on." And Vincent Martin says, "Don't stop, go, drive." Well, he got a little bit further down the road, about a half a block or so, and made a right-hand turn into Linden Avenue and pulled over and stopped. Officer Connors stopped his car behind him, got out, went to the driver's door with his flashlight in his hand and his gun in his holster, and the holster was strapped down. The gun was strapped down, and asked the driver for his driver's license and registration. At that point,
when you say his holster was strapped down, that means his weapon was not free to be drawn.
well, not to draw it, he would have to release the strap and then pull the gun out. And when the officer made the request to the driver, Vincent Martin, who was sitting in the right front passenger seat, got out of the car and asked Officer Connors, "Hey man, what's going on? What do you want?" Connors responded, "Sir, please get in your car, get in the car." And Martin asked again, while walking toward the back of the car, "Hey man, what you want? What do you want?" And Officer Connors told him again, "Get back in the car, please." He didn't. When Martin got to the rear of the car, Officer Connors had been moving slowly toward the back of the car, pretty much parallel with him. Martin pulled a gun that he'd been holding down by his side and shot one time, hitting Officer Connors in the neck. Officer Connors went down to the ground. We know what happened next because the occupants of the car, who had no idea that Martin was going to do what he did, Martin walked around, bent down from the waist with his right arm stretched forward straight, and fired 4 more shots into the side of Officer Connors' head. At Martin's trial, the medical examiner testified that the impact of those 4 shots on Officer Connors resulted in rocks and pebbles and so forth being implanted into his face. The people in the car, the other 3 individuals, saw what was happening through the windows of the car. Martin got back into the car and said, "Go, drive, go." And one of them said, "Hey man, why did you do that? What did you do that? Why did you do that?" And he said, and Martin responded, "Man, drive." And they drove off.
How was he apprehended?
Well, he was apprehended several days later. This happened on a Tuesday, and Martin was arrested on Friday. One of the individuals was arrested on the same day. I think the other 2 arrested the next day. And what was important in the trial, as far as I was concerned, was what happened in those intervening days, because Martin was staying with his girlfriend, and at one point in time, one day, he wanted to make sure or wanted to know what happened on TV. So he had her turn the TV on for the 6 o'clock news. And it was reported that a police officer had been killed and that there had been a robbery at a 7-Eleven. And he made no comment and turned it off, and he wanted to watch it again at 11 o'clock. Same thing. The following day, on Thursday, or Wednesday, he asked for the TV to be turned on again. And this time, his name was mentioned as one of the people, and the rest of the other people. And his girlfriend, after watching the show, said to him, "You got something to do with this?" And he said, "All over $20 little dollars." And she responded, "You did this? You shot a policeman?" And he said, "I had to, Sally. I didn't have no other choice. It was either me or him. Either he was going to kill me or I kill him." Now, this is important for two reasons. Number one, remember I told you that the $20 was taken from the 7-Eleven? 7-Eleven had had a series of robberies, and they had hired some security people to help them. And one of the things that the security people recommended was to remove some of the advertisements from the windows so people could see in, police could see in, and also note that they didn't give me the money. And that was known on the signs on the doors. And the cashier said we only had $20, and that's all we had, and all in $1 bills, nothing more than a $1 bill. And remember, he said either he was going to kill me or I killed him. When Officer Connor's body was found, his gun was still in the holster, still strapped in. He never made any move to take that gun out. So this was not something that Martin was responding to with what Officer Connors did. This was all on Martin wanting to get away from a robbery.
So Martin was tried. As a matter of fact, he was charged with capital murder. My understanding is that he was tried twice.
Yeah, he was charged with capital murder, use of a firearm in the commission of that crime, robbery, and use of a firearm in the commission of the robbery. Now, as you said, he was convicted twice and we had 2 trials. And here's where it gets interesting, specifically what Chairman Bennett made in her statement later. During the...
Yeah, and let me just say, and in order to put this in context, the chairman of the parole board, Adrian Bennett, made a statement at the time of the release of Martin, said that this is certainly a dark cloud of injustice, or there is certainly a dark cloud of injustice in this case. I want you to talk about that.
I'll take her to task with that 24 hours a day, 7 days a week, 365 days of the year. When this trial started, Jerry Davis and I came to 2 conclusions, two agreements. Number one, we wanted to do everything we could to make sure that Martin was convicted because we were convinced on the evidence we had that he was the guilty party. And number two, we wanted to make sure everything was done to make sure that he got a fair trial and no errors were committed in that trial. Now, as you know, the first trial resulted in his being found guilty of all charges and was sentenced to death. Under Virginia law, automatic appeal to the Supreme Court. The Supreme Court reversed that decision on the grounds that during the jury selection process, one of the potential jurors, a lady who never sat on the trial, never sat at the trial at all, was asked the question, as all of them were, do you believe that Martin has to prove his innocence? And she responded, if the Commonwealth has a job, I think, to find him guilty, produce evidence to show him guilty, and if he's not guilty, then he can show that. And the judge interrupted her and says, ma'am, that's not the law in Virginia. The law in Virginia is the defendant has the right to sit there and do absolutely nothing, and the Commonwealth has to prove beyond a reasonable doubt that he's guilty. Do you understand that? She said, fine. She said, I've never been in court before. I've been on a jury before. I don't know. If you tell me that's the law, I can follow it. And the judge says, if I tell you that's the law, can you follow it? And she said, yes, sir, I can. And the judge ruled that she had been rehabilitated by her answers and by her responses. And Martin's lawyer, Bob Johnson, used one of his peremptory challenges to remove her. And the Supreme Court said, no, judge should have removed her and he should not have had to have used one of his peremptory challenges. And that's why the case was reversed. That lady never sat on the jury.
So it never had anything to do with any of the evidence that was presented.
Absolutely nothing.
And it
Absolutely
had nothing to do with the fairness of any member of the jury who actually was selected to serve.
Not at all.
And then he was tried a second time and found guilty a second time.
He was tried the second time in December of that year, right before Christmas. We asked the judge to put it into January because nobody wants to try a case, especially that magnitude right before Christmas. And the judge said, no, we're going to try it. No, we did. And the same witnesses testified at the second trial, testified at the same time, first time.
His three companions.
The three co-defendants and his girlfriend, who was also charged as an accessory after the fact, all testified against him at the second trial.
Now I want you to tell folks who are watching what Judge Tucker said during the sentencing phase of one of these trials.
After the jury came back in the first trial and found him guilty and imposed the death penalty, the judge had a sentencing hearing, and he heard evidence from the Commonwealth and also from the defendant again, as the law required. And before he imposed a sentence, and I'm reading from the transcript, after consideration of the report and the argument of counsel made today, the court concurs fully with the jury verdict in imposing the death penalty. This was a cowardly, cold-blooded, brutal murder of a police officer who the evidence shows was in the proper performance of his duty and who the evidence shows never offered any physical threat to the defendant whatsoever. And here's the pertinent point that I think that Ms. Bennett either ignored or doesn't want to deal with. In the court's opinion, the penalty of death is the only appropriate punishment for the commission of a crime of this enormity by one whose record of violence is such that it would be unsafe to ever return him to society. And the judge then imposed a death penalty, which was later overturned by the Supreme Court of Virginia.
Now let me fast forward now to this spring. You know that the Virginia State Parole Board, on a vote of 4-0, with one member not voting, voted to grant parole to Vincent Martin. And I'd like to know, as one of the attorneys who prosecuted Mr. Martin, what your reaction was when you learned that this parole board was prepared to turn Mr. Martin back out into the community.
To put it bluntly, I was shocked beyond belief. Number one, I'd never heard that he'd been up parole. And when I heard this was his 21st time being up for parole, I was just flabbergasted. Mr. Martin has a history of violence. In 1971, he was convicted in a juvenile court of attempted murder and was given a suspended commitment. In 1972, in November, he robbed a supermarket in Henrico with a shotgun and was convicted of that robbery. In December of 1972, just 2 weeks after that previous robbery, he robbed a Safeway store in Henrico and with a sawed-off shotgun and was convicted of both of those offenses. He then went into the Department of Corrections and was released on August 10th of 1979 on discretionary parole. And it was roughly 3 months and 3 days later that he robbed a 7-Eleven and killed Michael Connors.
And some people will say that was a long time ago. And we've got the statement from Adrienne Bennett, who was chairman of the parole board until she left to take another position in the justice system. And she wrote that over the decades, Vincent Martin has demonstrated himself to be a trusted leader, peacemaker, mediator, mentor in the correctional community. Doesn't that warrant releasing him?
To put it bluntly, hell no.
Yes, that is a challenge question. I have my own opinion, which I'm going to get to.
My answer is hell no, and I'll tell you why. Vincent Martin is now 64 years of age. other than 2 weeks after he was released from parole in 1979, where he held a job that he was fired from because of misconduct, he has never held a job, period. Here's a guy you want to put into society at the age of 64 who has no marketable skills whatsoever, especially in a time when, with this coronavirus, so many people are being relieved of their jobs, the jobs being terminated, and employers when they do hire somebody, have a choice of hiring people with skills or somebody who, at the age of 64, has no skills. I mean,
there are no reentry services that are being
no,
offered.
that's what I understand.
Well, let me just tell you, and let me tell the people who are watching this, that this trusted leader, this peacemaker in the view of Ms. Bennett, this mediator and mentor in the correctional community, was up for parole just last year in 2019. And the parole board is required to list reasons why it denies parole to inmates every time that they come up. And just last year, the parole board said, in connection with the denial of his parole, number one, a couple of things that aren't surprising. His extensive criminal record that you just recited, history of violence you just recited, the crimes committed, capital murder. The board concludes that you should serve more of your sentence prior to being released on parole. But here's the kicker. Just last year, the parole board said your prior failures and or convictions while under the community supervision indicate that you are unlikely to comply with the conditions of release. What in the world changed between January of 2019, when that parole board made those findings, and earlier in 2020, when all of a sudden this same person is a trusted leader, peacemaker, mediator, mentor in the correctional community who ought to be released? One last thing. One of our watchers had a question. Cheryl asked, what if the Inspector General, and you know that there's an Inspector General's investigation ongoing into possible violations of the law, policies, or procedures by the parole board. What if the Inspector General has not completed his investigation by June 10 of 2020, the 30-day period that Mr. Martin's release has been delayed? Can Martin be set free by the parole board? Is there any accountability for the Virginia Parole Board and Chair Adrienne Bennett for failure to comply with state code and parole board policy and procedure? I don't know whether you have any thoughts about that. I certainly do.
I have some thoughts. The parole board serves at the pleasure of the governor. He's the one who appointed them, and he's the one who can terminate their services. If they release him, other than him committing a new crime, you know, there's no basis for sending him back to the penitentiary.
Well, and one additional thing that I know can happen is the parole board has the ability to hold a rescission hearing.
Yes.
And if information comes to the attention of the parole board that indicates that this is not consistent with the purposes of parole or the safety of communities, it can hold a rescission hearing before he's released, maybe even after, but certainly before he's released. They can rescind and wait until the Inspector General has finished the report. There's absolutely no reason they cannot do that. And in my view, they absolutely should. They ought to rescind on the basis of the information that has been presented, the objection of the Commonwealth's attorney in Richmond, the objection of the Richmond City Police Chief, the objection of the Chiefs Association. They ought to actually follow their process, hear from the family, hear from the law enforcement community, and reverse their decision.
My comment is, Ms. Bennett said that the parole board did an extensive review of his case. I believe she said over a 4-year period. Well, I challenge her on that, because if she's read the transcript of the original trial, she would have that. And all of the comments she's made have been based on the first trial. He is not serving a sentence based on that first trial. He is serving a sentence on the second base sentence imposed by the second trial. And here's the thing. she says there are inconsistencies between the testimony of the three co-defendants. Well, I defy you to find any three people who can witness this series of events over 5, 10, 15 minutes and give the exact same response to every single thing. Bottom line is they're all indicated who was a shooter, what he did, where he was sitting in the car, and if they, and I'll say to Ms. Bennett and anybody else who makes the comment, if the stories were identical, word for word, she would say they were rehearsed and they were coached, and that would be improper at all. It just defies comprehension, I think, to see why the parole board thinks this is a case that warrants for him to be released into the thing. 12 jurors on 2 separate occasions, not once, but twice, have heard the evidence, including Martin's testimony. And here's another key point. Martin said, "I wasn't there. I didn't do it." But he has no evidence, produced no evidence at all to corroborate his story. Nobody just say, "Hey, I was with Martin when this thing happened, so he couldn't have done it." Yet we have 3 other people who testified, "Yes, I was there and I saw him do it." Plus his girlfriend gave testimony about information that only the participant of the robbery would have known.
Yeah, I mean, between us lawyers, that's called an admission. All over $20.
All over a little $20.
Yeah. Well,
It's
listen.
it's ironic because Vincent Martin and Officer Connors were the exact same age.
That's terrible. And Officer Connors would otherwise be enjoying his life, enjoying his children and grandchildren right now. Listen, Stacy, thank you so much for your service to people of the Commonwealth of Virginia, to people of City of Richmond. Thanks so much for coming on and sharing a little bit of history about this case and your views and opinions. I certainly appreciate it. I know that our viewers do. This has been, for me, an informative week, and I think that these issues are so important that I hope that the mainstream media in Virginia will actually continue to cover this, because in my view, if these folks that we've been talking about this week, Deborah Scribner, Patrick Schooley, Vincent Martin, had been released during 1 month in 2019 or 2018, there would be a public outcry, the likes of which we have not heard. I think that the administration and the parole board are doing this deliberately in a time when the front pages of the newspapers are occupied with other matters. And it's a shame. They ought to be ashamed of themselves. This deserves public discussion and public scrutiny. The mainstream media needs to give it that on a continuous basis. The parole board was required to publish the names of the folks that it acted on their parole applications on in April. By the end of April, they still have not posted those names on the parole board website, and we are 2/3 of the way through May. Why is it that they're not putting them up? Who else has been released during the course of the past 6 weeks? Prosecutors aren't finding out. We're finding out after the fact. So, who knows? We may resume this series a little bit later, but Stacy Garrett, thank you so much for joining us. To our watchers who've joined us this week, thank you. I hope you will talk about this in your community, write letters to the editor, to the newspaper, write to the parole board and express your opinions, because this is critically important to the safety of our communities, safety of our children and grandchildren. Thanks so much, and good evening.
Thank you, Mark, for allowing me to participate in this forum. Appreciate it. And good luck to you, and thank you for your service, sir.
Thank you.